Yang amat berhormat Datuk Seri Diraja Haji Adnan bin Haji Yaakob, Menteri Besar of Pahang. Yang Arif Datuk Dr. Haji Muhammad Naim bin Mukhtar, Judge of the Syariah Court of Appeal. Yang berbahagia Puan Jumirah binti Marjuki, Timbalan Kanan Pendaftar Mahkamah Persekutuan Malaysia. Yang berbahagia Datuk Haji Zainul Rijal Abu Bakar, Presiden Persatuan Peguam Muslim Malaysia. Honorable Professor Datuk Seri Dr. Ashgar Ali bin Ali Muhammad, Dean Ahmad Ibrahim Kuliah of Laws. Professor Dr. Nik Ahmad Kamal Nik Mahmud from Ahmad Ibrahim Kuliah of Laws. Mr. Arun Kasi, Partner Tetuan Rusmah Arunan and Associates. Dr. Azmi Harun, Director of the Constitutional Oath, Rule of Law and Supreme Policing Rule of the Judiciary. Distinguished guests, respected lecturers and students of ICOL. Brothers and sisters, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to Ahmad Ibrahim Kuliah of Laws. We are gathered here on this auspicious Friday morning for the Symposium on Constitutional Oath, Rule of Law and Supreme Policing Rule of the Judiciary. First of all, on behalf of the organizing committee, we would like to thank Yang Amat Berhormat Datuk Seri Diraja Pahang Menteri Besar for gracing this event. We are truly honored with your presence. We also thank the lineup of distinguished speakers and everyone for their presence today. Mencari timba si anak dara, di bawah sarang burung tempua. Salam sembah pembuka bicara. Selamat datang untuk semua. To bless this event, it is my pleasure to call upon Brother Muhammad Al-Mubarak, a second-year student from Ahmad Ibrahim Kuliah of Laws, to recite Surah An-Nisa verses 134 until 136. Faltafaddal mashkura.
Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. من كان يريد ثواب الدنيا فعند الله ثواب الدنيا والآخرة وكان الله سميعا بصيرا. يا أيها الذين آمنوا كونوا قوامين بالقسط شهداء لله ولو على أنفسكم أو الوالدين والأقربين إن يكن غنيا أو فقيرا فالله أولى بهما فلا تتبعوا الهوى أن تعدلوا وإن تلووا أو تعرضوا فإن الله كان بما تعملون خبيرا. يا أيها الذين آمنوا بالله ورسوله والكتاب الذي نزل على رسوله والكتاب الذي أنزل من قبل ومن يكفر بالله وملائكته وكتبه ورسله واليوم الآخر فقد ضل ضلالا بعيدا صدق الله العظيم. السلام عليكم ورحمة الله وبركاته.
Thank you, Brother Mubarak, for the beautiful recitation. Distinguished guests, ladies and gentlemen, without further ado, I have the pleasure to invite Honorable Professor Datuk Sri Dr. Ashgar Ali bin Ali Muhammad, Dean of Ahmad Ibrahim Kuliah of Laws, to deliver his welcoming remarks.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Assalatu wassalamu ashrafi anbiya al-mursalin wa ala alihi wa ashabihi ajma'in. Yang amat berhormat Datuk Seri Diraja Haji Adnan bin Haji Yaakob, Menteri Besar of Pahang. Yang berbahagia Tun Abdul Hamid Muhammad, the former Chief Justice of Malaysia. Inshallah he will be with us shortly. Yang Arif Datuk Dr. Haji Naim bin Mokhtar, Judge Syariah Court of Appeal. Yang berbahagia Jumairah binti Marjuki, Timbalan Kanan Pendaftar Mahkamah Persekutuan Malaysia. Yang berbahagia Datuk Haji Zainul Rijal Abu Bakar, Presiden Persatuan Peguam Muslim Malaysia. Profesor Dr. Ni Ahmad Kamal Nik Mahmud. Mr. Arun Kasi, Partner, Tetuan Rosmah Arunan and Associates, distinguished guests, the Pahang Exco members, respected lecturers, students of high call, brothers and sisters, ladies and gentlemen, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh, and a very good morning to all of you. First and foremost, I have the pleasure of welcoming our distinguished speakers and all of you to this symposium with the theme Constitutional Oath, Rule of Law, Supreme Policing Role of the Judiciary. Ladies and gentlemen, we are in Malaysia upholding the constitutional supremacy as per Article 4, Clause 1 of the Constitution. The Constitution provides for the three main organs of the government, the executive, the legislature, and the judiciary, pursuant to Articles 39, 44, and 121 of the Constitution, respectively. Article 124 of the Constitution deals with oath of office and allegiance for the judiciary, namely to preserve, protect, and defend the Constitution. The rule of law implies that every person is subject to law, including the lawmakers, law enforcement officers, and judges. It serves as a check against abuse of power. Ladies and gentlemen, the greatest challenge in any democratic state is to balance the might of the state and the rights of citizens. In Malaysia, we implement dual legal system, the Sharia and common law, and we have dual court system, the civil and the Sharia courts, which is sanctioned by Article 121, Clause 1A of the Constitution. This article excludes or ousts jurisdiction of civil courts in matters within the jurisdiction of the Sharia courts. The recent federal court's decision in Indira Gandhi's case 2018 had raised some pertinent issues such as the constitutional role of the judiciary, which basically forms the theme of this morning's conference. Justice Tan Sri Zainul Ali, who delivered the unanimous judgment of the federal court, had stated inter alia that the inherent judicial power of the civil courts in relation to judicial review and questions of constitutional or statutory interpretation is not and cannot be removed by the insertion of Clause 1A into Article 121. With the marked differences in the establishment and the constitution of the civil and Sharia courts, Her Ladyship added, I quote, "The perception that both courts should exercise a mutually reciprocal policy of non-interference may be somewhat misconceived and premised on the erroneous understanding of the constitutional framework in Malaysia," unquote. Ladies and gentlemen, this decision in Indira Gandhi's case consolidates the view that any act, including an act amending constitution passed in accordance with Article 159, Clause 1 of the Constitution, may be struck down if it is in conflict or seeks to alter the basic structure of the Constitution. Ladies and gentlemen, this doctrine of basic structure has gained widespread acceptance in India since the early 70s. In a number of cases such as Kesa Wanandan Bharati, 1973, Indira Nehru Gandhi, 1975, Minerva Mills, 1980, Raja Rampal, 2007, to name but a few. Now, this doctrine has found its way in the Malaysian system in the case of Semenyih Jaya, Sdn Bhd 2017, and now in Indira Gandhi 2018. The federal court in Indira Gandhi's case stated that the vesting of judicial power of the federation in the civil courts formed part of the basic structure of the Constitution and could not be removed even by constitutional amendment. Now, in light of the foregoing, this symposium is organized to discuss, among others, the supreme policing role of the judiciary, and we are pleased to have our distinguished learned speakers who will be delivering and deliberating on this theme. Ladies and gentlemen, before I end, I would like to express my heartfelt appreciation to our distinguished speakers who have taken time off from their busy work schedules to be with us to share their views on the theme of the symposium. To Dr. Azmi Harun, the director of the symposium, members of the organizing committee, Law Student Society, ICOL Press, for their hard work in ensuring the success of this symposium. I would also like to acknowledge the Pahang State Foundation for their support and sponsorship for this symposium. On behalf of the Kuliah, I once again welcome all of you to this timely discussion and hope that you will benefit immensely. Thank you, and wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Thank you very much, Honorable Datuk Sri. Distinguished guests, ladies and gentlemen, we now move on to the main agenda. The first keynote address will be delivered by Yang Amat Berhormat Datuk Sri Diraja Haji Adnan bin Haji Yaakob, Pahang Menteri Besar. Yang Amat Berhormat Datuk Sri Diraja Haji Adnan bin Haji Yaakob, was born in 1950 and raised in Bentong, Pahang. He graduated from secondary school and became a teacher in 1969. He then attended the University of Malaya from 1972 and graduated in 1975. He studied for his Diploma of Education until 1977. He contested and won the Pahang State Legislative Assembly seat in Pelangai during the 1986 general election. He was elected UMNO Division Chief in Bentong in 1987. On 22nd May 1999, he was appointed as the Menteri Besar of Pahang. Without further ado, please welcome Yang Amat Berhormat Datuk Sri Diraja Haji Adnan bin Haji Yaakob.
Before I contested elections, I was a IIU doing my law. I was a second batch student in 1984, but I didn't complete, not because I failed, but because I was called to contest elections. And I became the Menteri Besar not on the 22nd, on the 25th May 1999. Just a little bit of correction. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Yang bahagia Tun Abdul Hamid Muhammad, arriving at 10, I was made to understand. Yang bahagia Ya Arif Datuk Dr. Haji Naim Mukhtar, Judge of the Syariah Court of Appeal. Yang bahagia Puan Jumirah binti Marjuki, Timbalan Kanan Pendaftar Mahkamah Persekutuan Malaysia. Datuk Haji Zainul Rijal Abu Bakar, Presiden Persatuan Peguam Muslim Malaysia. Yang berbahagia Datuk Sri Profesor Azgar Ali, Dean of the Faculty. I should be putting your name on the top because you're my teacher too. Yang bahagia Profesor Dr. Nik Ahmad Kamal, Nik Mahmud, Mr. Arun Kasih, Dr. Azmi Harun, Director of the Sympossium, distinguished guests, respected and learned lecturers, students of ICOL, not forgetting my colleagues from Pahang, the state ESCO members, Datuk Sri Wan Rosdi, Datuk Sri Shafiq, Datuk Sri Shaniza, and the Deputy Speaker, Datuk Sri Muhammad Jaafar, and Brother Reza, a practicing lawyer, and a few others. Brothers and sisters, ladies and gentlemen. I won't take long, you don't have to worry. My speech normally lasts between 5 to 10 minutes. But I can guarantee you, in view of the very hot topic, controversial topic that's given to us, my speech might take 3 hours. No, don't worry, very short one. Alhamdulillah, praise be to Allah subhanahu wa ta'ala. And thanks to the organizers for inviting me, especially the Dean, Professor Dr. Ashgar. I'm very glad to be in the midst of good legal brains. If Tun Hamid Muhammad is here, one of the best legal brains, I would say, in the midst of the best legal brains among intellectuals in this discourse. I'm happy I'll be able to meet Tun Hamid and learned professors, academicians, legal practitioners, including Brother Arun, my newfound friend. And not forgetting the students of IIUM. Now, if you look at the title, we have 3 elements there: constitutional oath, rule of law, and supreme policing role of judiciary. To me, the first 2 are not that significant compared to the number 3. That is the supreme policing role of judiciary. Now, notwithstanding, I wish to touch a little bit on the constitutional oath and also rule of law before dwelling into supreme policing powers of the judiciary. Now, the constitutional oath, if you have a look, even His Royal Highness, the Yang di-Pertuan Agong, takes the oath. And just 1 second. Under Article 124, judges of the Federal Court, Court of Appeal, High Court, take the oath of office and allegiance. For what? To preserve, protect, and defend the Constitution. Under Article 43(6), government ministers take oath of office too, in the presence of Yang di-Pertuan Agong, also to preserve, protect, and defend the Constitution. Members of Parliament take oath of office too, under Article 59(1), also to preserve, protect, and defend the Constitution of Malaysia. Even His Majesty Yang di-Pertuan Agong take the oath, saying will faithfully perform the duties in the administration of Malaysia according with its laws and constitution. Meaning to say, those who hold office, even salaried officers, take the oath. And this oath originates from the Constitution of Malaysia. Monarchs are sovereigns. Constitution is supreme. We'll go further into that. Now, as for the rule of law, this is so common among law students and lecturers. When we say rule of law, mention rule of law, we always remember Albert when some people say Daichi, some people say Daisi. Now, it consists of 3 main elements: supremacy of the law, equality before the law, and referring to unwritten British Constitution, Daisy was saying the principles of the Constitution are a result of judicial decisions. That's the third concept of the rule of law. In the political and legal theory, it has come to be read in a narrow sense, that the government shall be ruled by the law and be subject to it. The idea of the rule of law in this sense is often expressed by the phrase sovereign by law and not by man. That's just a little bit about the rule of law. Now, we have a look at the function of the judiciary, the judge, or the court. The duty of the court and its only duty is to expound the language of the Act in accordance with the settled rules of construction. Lord Macnaghten in Vetcher and Sons and London Society of Compositors, quoted by Raja Azlan Shah in Lo Kui Chun. In Chow Tiam Guan against the AG of Malaysia, the learned judge said, the law may be harsh, but the role of the court is only to administer the law as it stands. Basically, the role of the judiciary is to interpret the law as it stands. Can I have some? That should be the function of the judge, the court, or the judiciary. I humbly submit that the development, as I can see, and as indirectly mentioned by Professor Asgar, makes me wonder whether there will be a clash between the judiciary and the parliament later on. It's for time to say. Lately, judges tend to embark on what we call judicial activism. Simply means judges make the judgment based on their personal opinion. That's all. I don't have to quote so many writers here. Some refers to judicial ruling based on personal opinion rather than on existing law. And under this judicial activism, judges allow their personal views about public policy to guide their decisions. Now, this includes overturning laws as unconstitutional, overturning judicial precedent, doctrine of stare decisis, ruling against the preferred interpretation of the Constitution. This is a ramification of the introduction of basic structure into our Constitution. Supporters of judicial activism say that it is a legitimate form of judicial review. And so, as they say, interpretation of law must change with changing times. But critics of judicial activism charge that it usurps the power of elected government, damaging democracy and rule of law. Activist judges discharge their functions exceeding what the Constitution provides. That's basically what it's all about, judicial activism. Now, it's up to the judiciary to determine their, not to say their own future, but the way they run the judiciary. But then we have to remember, in Malaysia, we have the doctrine of separation of powers, where the judges have to interpret the law as it stands, and making changes to the amendment, making changes to the law is the duty of the parliament, whereas the executive carries on administering the country. Now, this basic structure of the Constitution, it originated from the Indian Supreme Court in the case of, as mentioned by Professor Dr. C. Ashkar just now, Kesavananda Bharati against State of Kerala, decided in 1973. Now, the court held that Article 368, that is the enabling article of the Indian Constitution to amend the Indian Constitution, that the article does not enable Parliament to alter the basic structure or framework of the Constitution. Now, the basic structure includes the system, government of republic and presidency in India, basic rights, freedom of the fundamental liberties and whatnot. Those are considered to be the basic structure of the Constitution. Now, the judgment also introduced certain provisions of the Indian Constitution form the basic structure of the Constitution. And based on this decision, the court will decide which provisions of the Constitution form the basic structure on a case-by-case basis. The court has the power to determine what is the basic structure, and this basic structure cannot be amended at the whim and fancies of the Parliament. Now, it means that the amending power of Parliament is limited. But then we have to look at the background when Kesavananda Bharati was delivered. It was during the so-called government of Indira Gandhi, who were very strict, very harsh, and as a result, this case came up and the court ruled as it ruled by introducing the concept of basic structure of the Constitution. Now, in Malaysia, the power to amend the Constitution is vested in Parliament. That's very clear. And nowhere does the Constitution say that certain articles form the basic structure of the Malaysian Constitution and cannot be amended. Nowhere. Nowhere does it say that the court may decide on a case-to-case basis which articles form part of the basic structure of the Constitution or not, and therefore may or may not be amended. There is no such thing. There is no such thing in the Malaysian Constitution as a basic structure of the Constitution. I misplaced some of the notes. My SP of the cuff. Article 159 gives power to Parliament to amend the Constitution. There are 4 ways of amending the Constitution. That was mentioned in Law Kui Chun. Number 1, Clause 3. That is, the Constitution can be amended by 2/3 majority. And then Clause 4, by just simple majority. And then Clause 5, by 2/3 majority of Parliament plus the consent of the Conference of Rulers. Article 161 E2 provides that the Constitution can be amended by 2/3 majority plus the consent of the governors of the East Malaysian states, namely Sabah and Sarawak. Those are the 4 ways that we can amend the Constitution. And interestingly, Parliament can amend Constitution although the amendment is inconsistent with the Constitution. That is very clear. Now, if the supreme policing role of judiciary is to be applied strictly, it means that the judiciary is usurping the power of Parliament. Now we must remember, Parliament is made up of presently 222 members, elected by the people, but not the judiciary. The judiciary can have a quorum of 7 and then make a ruling against the Parliament according to their interpretation. I don't think that is in line with the concept of doctrine of separation of powers. Now the only way out is for Parliament to outdo, nullify whatever the court decision is. This has happened so many times. If the judiciary makes judgment which is not incompatible with what Parliament is having in mind, Parliament will normally amend the law or amend the Constitution. But the problem is that now, is that the ruling party has not had the 2/3 majority since unit election 2008, 2013, and this time around we just don't know. So the only way for Parliament to make sure that the law stands as it is and to avoid the judiciary encroaching into their realm is to put forward constitutional amendment. But one thing about the Parliament and the Executive, the people, the human beings in the organization sometimes are not sensitive. I take, for example, the case of Bonsam Unit against Arona. Arona Properties and Bonsam Unit. 2001. The Federal Court, with due respect, wrongly decided the case. It said that the concept of indivisibility of title is to be immediate. I'm so sorry. Somewhere along the line, probably the Law Revision Commission people, they are not aware of this. So this wrong decision carried on at the expense of so many landowners, original landowners, genuine landowners who lost their land just because of the decision in Arona Properties. And it took a case from Kuantan, Pahang, from our state, Tan Ying Hong, to enable the Federal Court to rectify the error in Arona Properties. That was in 2010, after 9 years of mistake, gravely caused by the judiciary at that time. And that points to the fact that sometimes the doctrine of stare decisis cannot be followed. Because after Arona, all the cases, all the court fall in Arona Properties when it was wrong. So it needs another case to rectify it. I don't intend to go further, although I have a lot of points, and I think the notes are missing. What a careless Chief Minister, what to do? Just one last point before I end my keynote address. Just please bear with me. It's quite an important point. Now, as a result of this clash between the organs of the government, we have the legislature, we have the judiciary, and we have the executive. People start talking about supremacy. Which is supreme? Now, Article 4 of the Constitution says that the Constitution is supreme. But then, despite being supreme, the Constitution can be amended by Parliament. through Article 159. So we can say that Parliament is supreme. Now, if Parliament doesn't comply with the requirement of the Constitution, the judiciary is given the power to declare that the act of Parliament is wrong. So in this case, judiciary is supreme. But then we go down the line. Any bill of Parliament, that is where we want to create an act of Parliament, we have to move the bill first, or an amendment, proposed amendment. Well, it comes from where? From the executive, from the minister concerned, from the Prime Minister. So we can say that the executive is supreme. Now the best thing is, you just do your own work. That's all. Judiciary, you do your own work. So is Parliament and Executive. Sometimes there'll be intertwining of activities. As you can see, judges are not supposed to make laws, but they make laws through their judgments. Even judges make the rules of the court. The judges make the rules with a representative from AG's chambers, bar council present, but made by the judges who are not supposed to make law. So there's some encroachment into each other. That's tolerable. Even executive make laws through delegated legislation. They form tribunal, which is not made up of legally qualified people. They're encroaching into the function of the judiciary, but that's okay. So in the end, we cannot talk about supremacy. I think the best way is for the organs of government to do their own work. And if there is an encroachment by any organ, any branch of government into the other branch, it doesn't augur well for the country. And remember, for any problem, there's always a solution. And for an action, there's always a reaction. We have to remember that. I think the best way is to mind our own business. So when we say about, or talking about supremacy, don't forget, no one is supreme. Who is supreme? Allah the Almighty is supreme. Wassalamualaikum warahmatullahi wabarakatuh.
For the second keynote address today, we are honored by the presence of our distinguished speaker, Tun Abdul Hamid bin Haji Muhammad, accompanied by his beautiful wife, Tuan Puan Hamidah. Tun Abdul Hamid bin Haji Muhammad was born on 18 April 1942 in Permatang Tinggi, Bakar Bata, Kepala Batas, Penang. He read law at the University of Singapore and graduated with LLB honours in 1969. Tun Abdul Hamid joined the Judicial and Legal Service and had served as Magistrate, President of Sessions Court, Assistant Director of the Legal Aid Bureau, Deputy Registrar of the High Court, State Legal Advisor, Senior Federal Counsel of the Inland Revenue Department, and Head of Prosecution in the Attorney General's Chambers. On 1st May 1990, he was appointed as Judicial Commissioner and later confirmed as High Court Judge. Subsequently, he was elevated to Court of Appeal Judge, Federal Court Judge, and President of the Court of Appeal. On 1st November 2007, Tun Abdul Hamid was appointed as the Chief Justice of Malaysia. He retired on 18 October 2008. In the course of his career, he was also appointed as Judge of the Special Court and Judge of the Shariah Court of Appeal for the state of Penang, making him the judge that had served in all the courts in the country, civil as well as Sharia. Tun Abdul Hamid was also instrumental in the drafting of the laws for use in the Sharia courts since 1981. The Sharia Criminal Procedure Enactment and the Sharia Civil Procedure Enactment of the state of Kelantan were passed by the state legislature when he was the state legal advisor of Kelantan. He had also served as chairman of the Civil Law and Sharia Technical Committee for the state of Penang and a member of the Civil Law and Sharia Technical Committee at national level. Tun Abdul Hamid had presented numerous working papers, delivered many keynote addresses and speeches at conferences, seminars, workshops, forums, and muzakarah, both locally and abroad. Among them was the Abdul Razak Al-Sanhuri lecture at Harvard University on 6th November 2008. Currently, Tun Abdul Hamid is still active, serving as the chairman of the Law Harmonizing Committee of Bank Negara Malaysia, a member of the Sharia Advisory Council of Bank Negara and the Security Commission, a member of the Judicial Appointments Commission, and a member of the Sharia and Civil Law Harmonizing Committee of Brunei Darussalam. On 15 October 2011, he was awarded the Honorary Doctorate in Management by University Tenaga Nasional Malaysia, UNITAN, and he was also conferred the honorary degree of Doctor of Philosophy in Sharia and Judiciary by University Science Islam Malaysia, USIM. Without further ado, I now welcome Tun Abdul Hamid bin Haji Muhammad.
Assalamualaikum warahmatullahi wabarakatuh. You know, I have undergone 6 surgeries, but all are from the neck downwards. So inshallah, anything above the neck is still original. Subject to wear and tear. Yang amat berhormat Datuk Seri Diraja Haji Adnan bin Haji Yaakob, Menteri Besar Pahang, professors, datuk-datuk, participants, ladies and gentlemen. When Dr. Azmi told me about this symposium, I said to him that if the organizers were willing to hire an ambulance to take me there, I would be prepared to go. As it turned out to be, IIUM has its own ambulance, so I'm here. I only asked for 15 minutes to say what I want to say regarding an issue which, to me, is of utmost importance to lawyers, parliamentarians, the executives, politicians, indeed to every citizen of this country. Unfortunately, most people are either not aware of it or do not seem to realize its implication. We talk about the separation of powers between the legislature, the executive, and the judiciary. Very often, we focus on the executives encroaching on the jurisdiction of the judiciary. But do we ever think of the reverse, i.e., the judiciary encroaching on the jurisdiction of the executives and the legislature? Article 159 of the Constitution provides that certain parts of the Constitution may be amended in a certain way. The power to amend the Constitution is vested in the Parliament. Nowhere does it say that certain parts of the Constitution cannot be amended. Nor does it say that judges may amend the Constitution to the effect that certain provisions of the Constitution cannot be amended by Parliament. Yet, what happened in Siwarasa Rasaya against Badan Pegawai Malaysia 2010 to MLJ 333 and Semenyih Jaya Sdn Bhd against Pentadbir Tanah Hulu Langat 2017 3 MLJ 561. Let me tell the story from the beginning. In 1973, the Indian Supreme Court decided the case of Kesavananda Bharati against State of Kerala, AIR 1973 SC 1461. The court held that Article 368 of the Indian Constitution does not enable Parliament to alter the basic structure or framework of the Constitution. The effect of that judgment is that certain provisions of the Indian Constitution form the basic structure of the Constitution. The court will decide which provisions of the Constitution form the basic structure of the Constitution on a case-by-case basis. The court will then use the basic structure principle as the basis of its power to review and to strike down amendments to the Constitution enacted by Parliament which seeks to alter the basic structure of the Constitution. In other words, the power of Parliament to amend those parts of the Constitution which, according to a judge or judges, form the basic structure of the Constitution is removed by the judge or judges. That case was decided by a slim majority of 7-6. It is said that when the case was decided, the perception by the majority bench that elected representatives could not be trusted to act responsibly was unprecedented. If I may add, during my visit to the Supreme Court of India when I was a Chief Justice, I asked a Supreme Court judge for the justification for the Supreme Court to take over the supervision of investigation, remember, investigation, in the Indira Gandhi case. His reply was, "We have no choice. The police are so corrupt." My question, listen, my question is, if members of Parliament or the executive think that judges are corrupt, does that give them the power to transfer cases in court to be decided by them? The reverse. If when judges think police are corrupt, the court can take over supervision of the investigation. If members of Parliament, if the court think, judges think that members of Parliament are corrupt or inefficient, the court can take over the function of legislating, making law. Can the reverse be done? Should be. I mean, if there is the thing, and it becomes illogical, it should. And that's why I say it shouldn't be. So, I remember, this is another. I remember reading an article in the Time magazine 7 or 8 years ago regarding the Parliament of India. I kept that article, but due to moving house and my present condition, I am unable to locate it. The article exposed some of the unimaginable facts about the members of the Indian Parliament. I'll tell you just one of them. At the time when the article was written, 17 members of Parliament of India had conviction for murder hanging over their heads. 17 of them had been convicted for murder, and they are still members of Parliament. As their appeals were still pending and their sentences were suspended until the final disposal of the Supreme Court, they were free to stand for election and function as members of Parliament. Since it took about 30 years for a case to be finally disposed of, that period is long enough to cover their whole political career. Ya, Tuan Sri, 30 tahun cukup lah kan, orang politik. Those were the circumstances in India. that led the judges to come out with that and similar judgment. Whatever it is, even if it is true, and this is my view, I say, even if it is true, I say that that is not a justification for judges to usurp the jurisdiction of the legislature. Whatever happened in Parliament does not give the power to judges to take over the power of Parliament. No. The solution there is somewhere else. Vote them out. Yeah. Back in Malaysia, lawyers, academicians, and others applauded the judgment. Lawyers were happy because they now had a new argument to support their cases against the government, and with it the opportunity to make a name and money in, quote, developing the law. Academicians, okay, academicians here, you pun kenal juga. Academicians were excited about, quote, a new development in the constitutional law, unquote, that they could write on or tell their students about. Yet there were those who at that time felt that in this country the same government dominated by one party had remained too long and too strong. At least to them, with that judgment, the court is there, quote, to provide a check and balance, unquote. Yet, there were those who always looked up to the Indian Supreme Court and had strong sentiments for anything coming from India. So lawyers in Malaysia, led by the successive presidents of the Bar Council, namely GTS Sidhu, Raja Aziz Edros, and Param Kumarasamy, tried hard to influence the then Federal Court to adopt the principle. In my condition, I am unable to do a research to find out whether Gopal Sri Ram, then a practicing lawyer, was one of them. Perhaps he can enlighten us by just saying yes or no. However, their attempts failed. The Federal Court in Low Kui Chun against the government of Malaysia, 1977 to MLJ 187, rejected it. Tun Sufyan, Lord President, and Wan Sulaiman, federal judge, wrote separate judgments giving reasons why they were not inclined to follow it. That judgment was followed by the Federal Court in Pang Chien Hock against Public Prosecutor, 1980, 1 MLJ 70. In 1989, the case was followed by the Singapore High Court in Teo So Lung against Minister for Home Affairs, 1989, 2 MLJ 449. Loh Koi Chun stood at the law of this country for 33 years. In other words, for 33 years, that principle of basic structure was rejected by the court in this country, and it stood for 33 years. No way. One would have thought that the issue regarding the basic structure of the Constitution was settled. However, that was not to be, thanks in particular to one man. Towards the end of his career, Gopal Sri Ram, Judge Court of Appeal, was promoted to the Federal Court. He was a member of the panel that decided Sibarasa Rasaya against Badan Peguam Malaysia and another. Even though he was the most junior member of the panel, he delivered the judgment of the court. The issue in that case was whether Section 46A1 of the Legal Profession Act 1976 was unconstitutional. The court, through the judgment of Gopal Sri Ram FCJ, held that it was constitutional. I have no problem with that decision. But I disagree with the smuggling of the basic structure principle into this country through that case. Because, one, it is not at all necessary for the decision of that case. What was being challenged in that case was the validity of Section 46A1 of the Legal Profession Act. No one was trying to amend the provision of the Constitution. What was the relevance of the basic structure principle? Two, the Kesavanana Bharati case, the Indian case, was followed without analyzing the case or the circumstances surrounding it. The learned judge either brushed aside or ignored the earlier judgments of the federal court, which had stood for more than 30 years. And this, number three, this is more important. In so doing, the court was usurping the function of Parliament to amend the Constitution. Indeed, even Parliament cannot make such amendment. In other words, even Parliament cannot make a law to say that the certain part of the Constitution cannot be amended. Reason? Because Parliament cannot bind itself from making laws inconsistent with the existing law. And Parliament cannot bind the next Parliament. Next Parliament can amend whatever is law made by the previous Parliament. Otherwise, you can't amend any law. It's as simple as that. If you say that Parliament can make a law to bind the next Parliament from making a law contrary to it, it doesn't work. Because next Parliament can just amend it. Because if you can do that, as I said, it means no law can be amended. Once you make a law, then you cannot amend. Then how is a Parliament going to function? So even Parliament cannot make such a law, what about judges? Where do the judges get the power from? 7 years later, the federal court handed down the judgment in the case of Semenyih Jaya Sneha Berhad against Pentadbir Tanah Ululangan, 2017, 3 MLJ 561. That judgment, written by Zainun Ali, federal court judge, relied on the judgment of Gopal Sri Ram FCJ in Sivarasa Rasaya as the authority for the introduction of the basic structure principle in this country. Without any question, it also ignored or missed Pang Cheng Hock and Teo So Lung. On 14 and 15 June 2017, the New Straits Times published my article in 2 parts titled, "Not for Judges to Rewrite the Constitution," and "No Judge is a Parliament." I understand that Datuk Gopal Sri Ram wrote a reply. Then, on 29 January 2018, the federal court handed down the judgment in Indira Gandhi against anak perempuan Muto against pengarah Jabatan Agama Islam Perak. Again, the judgment was written by Zainun Ali FCJ. Even though the basic structure principle was not at all an issue in the case, the learned judge took the opportunity to endorse Semenyih Jaya to reaffirm the basic structure principle. As a result, the basic structure principle becomes the law of this country after 33 years. Perhaps the happiest person is Datuk Sri Gopal Sri Ram, as can be seen from his press statement dated 31st January 2018, see freemalaysiatoday.com. I must emphasize that I am objecting to the introduction of the basic structure principle invented by the Indian judges on ground of principle and nothing else. We cherish the doctrine of independence of judiciary, separation of powers, rule of law, parliamentary democracy, and supremacy of the Constitution. Now, judges are giving themselves the power to amend or rewrite the Constitution. I call it is dictatorship by the judges. Those young people or old people of my age, no, we lived during the Cold War. We used to come across the term dictatorship of the proletariat. Remember? So now we have dictatorship of the judges, if you allow this to go on. I stand by what I had said in my judgment. This is what I said. No judge is a parliament. If the doctrine of separation of powers were to have any meaning, all the three branches of the government, i.e., legislature, executives, and the judiciary, must respect each other's jurisdiction. I hope, that's why I want Datuk Sri to be here. He's a politician. I want him to hear what I'm going to say now, and I hope he will viral it to all the members of parliament, irrespective of what parties. I hope our members of parliament are aware of what is happening. What recourse do they have? The answer is to revert to the Constitution. The power to amend the Constitution is vested in Parliament in the name of parliamentary democracy and separation of powers. All members of Parliament, whether they are from the government or the opposition, should come together and move a bill to amend the Constitution to the effect that Parliament may amend any part of the Constitution, provided that the procedure laid down by the Constitution is followed. The original position must be restored. If you would like to read the more detailed discussion on this subject, please read my article titled "Not for Judges to Rewrite the Constitution," available on my websites. tunabdulhamid.my or tunabdulhamid.me. They are all there. Well, ladies and gentlemen, I have said what I want to say. Thank you. Think about it. And thank you. 15 minutes. I hope I don't exceed 15.
After I read your article, Straits Times, I sent a message to the Prime Minister immediately. But sad to say, we don't have the two-thirds majority. It's a bit difficult for the government party and the opposition party to come together just to table the necessary amendment. And number two, I'm a bit perplexed, you know. Why the other judges on the bench don't write the decisions? That is a bit perplexing. Unlike the days of Tun Sopian, Raja Azlan, H.S. Ong, H.T. Ong, they write the judgment individually. But in this case, what Tan Sri Datuk Sri Gopal Sri Ram wrote, they just follow. And there's a very good follower in FCJ, they're not early. That's a problem now. So the only recourse is to go to Parliament and amend the Constitution to nullify the ruling of the court. So thank you.
Actually, I'm very happy you did what you do and you realize the importance of it. Unfortunately, when that judgment was handed down and everybody talks about vetting structure, wow, nobody thought about the way I think. I think I can say nobody thought the way I think. Semua ramai lagi suka basic structure, very structure. That's the trouble. We never analyze, we never think deeply. And Gopal Sri Ram, with respect, was too happy to introduce or import whatever comes from the Indian Supreme Court. And then our judges, unfortunately, they prefer to rely on someone else to write. And you just follow. That's a problem, you know. And people don't think seriously. And that's why I told Dr. that when I heard about this, I want to come and say my view and then let you think about it. Because other people, otherwise, you know, people would just accept it and they don't realize what happens. It means there will come a day when Parliament passes a bill and then it goes to court. The judge say, oh, this is infringing on the basic structure. That amendment by the court, by the Parliament is struck out. And my greatest fear is this, and it is happening. If you read my writings available on my website, I keep saying that when we have an issue, we have to look at our own constitution. Because our constitution is different from the constitution of India, from the constitution of the United States, and so on. Indian Supreme Court starts off with the preamble. With the preamble, India is a secular state. It starts off like that. Even United States Constitution, it doesn't say so, but of course it is secular. By the third article, we already say Islam is religion of federation. So we are different. And our Constitution has one part which provides for Islamic law to be made the law of this country for Muslims. We have a special provision for that which is in list 2 of Schedule 9. So, if Indian Supreme Court has decided now that Sharia court is unconstitutional in India, are we going to follow? Are we going to follow? We have our special provisions. So that's why my concern is when judges start looking at the articles written by other people in some other countries and start looking and following judgments of courts in other countries without analyzing what's the provision of the Constitution, without analyzing the circumstances, as I have told in this case, circumstances in India. You know, we just take the photograph, cut and paste. Now the problem with computer and research officers, previously there was no computer, no research officers. Judges have to read the cases themselves. And that's why when you read the earlier judgment, judges, and Yusuf Abdul Qadir was very good for this. He will summarize the principle of the case in one sentence, and at the end of it, he just cite the cases. In other words, he has read the cases, he has compressed it in one paragraph, and if you want to look for the authority, here you are. But now what is happening with research officers? Number one, the research officers, will start researching all over the world, go through the internet, all over the world. They just cut, and put. All right? and give it to judges. And judges will paste it. So you get cut and paste judgments. And the judgments become very long. If you read properly, you read now. It's just cut and paste. It's no longer analytical judgment. And that's my fear. And so my fear is that, and Sri Ram has been gunning after me. Even when I write in Utusan Malaysia, he gets someone to translate for him and reply. You just imagine. Just imagine. Because I say, Islamic offenses which are provided for in the second list, in list 2, yani against precepts of Islam. Those offenses, whether or not they contravene any provision of the Constitution, including, for example, the freedom of religion, equality, and so on, they are still valid. In other words, I say those provisions of the Constitution, including regarding, for example, the freedom of the religion, does not apply to Islamic law offenses. Otherwise, you can't even make someone pay zakat, because there is making it compulsory for someone to pay zakat. Freedom of religion means freedom. I want to do it, I want to practice, I don't want to practice, I want to pay, I don't want to pay, it's up to me. Even the offense which we have in so many enactments, tak sembahyang jemaat selama 3 hari betul-betul, you can't have such offense. Why? Because freedom of religion. So I say those provisions regarding freedom of religion and equality, for example, do not apply to the offenses under second list, because those offenses are specifically provided for. The Constitution says you can make these offenses, you can create it. So, but Sri Ram is deadly against it. He has been following me, and then he has been telling, no, these provisions will apply. In other words, they are going to use those provisions to strike down the offenses that we make under Islamic law. Now I heard that a few days ago, or what, even the Bar Council is having a seminar on Islamic law. Why are they so concerned about it? And I keep saying, Islamic law offenses are for Muslims. Why are the non-Muslims so concerned about it? We never bothered, or we never comment when they want to poke their cheeks with spears or that. They can do whatever they do in the name of their religion. We don't. Why are they so interested? And they want to control what we do for us. And that is what I'm afraid. I'm afraid that Muslims don't realize it. Yeah, Muslims just follow. They don't realize it. So it's now, I come here, I want to make, so long as Allah Ta'ala allows me to think and to speak. As I said, so long as what is above the neck is still original. Is still original. So hopefully if you can carry me, I will still come and speak when I think it is necessary like this. So please think, I don't say I'm right, but I'm giving my opinion and my reasons. Think about it. And don't just accept anything when you read, analyze, think about it. And I always say, when I say orang Melayu marah, I say Melayu tak fikir. Malays don't think. No. Melayu, mana Melayu ada kata, saya fikir. Orang Melayu tak guna perkataan, saya fikir. The way we say, I think. Dia kata, saya rasa. Rasa aja. Lepas tu lagi satu saya ingat. Jadi pada saya rasa tu dia ikut. Nobody really thinks. Ikut ramai-ramai. Nobody thinks. And then yang saya ikut, instead of saying the word fikir, dia kata, saya ingat. Ingat tu apa? bila dia ada satu masalah, dia ingat bapak dia dulu, tok dia dulu buat macam mana, how they handle that situation. Dia pun macam tu lah. They don't think on their own. Ini tak mau. Melayu kena buang, fikir. Don't just accept what you get, what you hear. You know, jangan ikut, jangan nak senang je orang buat. Judgment pun orang tulis, wah, they are too happy to write the judgment because they have an agenda. They have agenda. Dia dapat peluang sikit saja, they just smuggle it, and then we follow. That's the problem. That's the reason why I'm here.
Thank you very much, Tun Abdul Hamid, for the most insightful keynote address. We received information that our speaker, Dr. Dominic Joseph Putucherry, is unable to attend due to an unavoidable circumstance. Thus, I now have the pleasure of inviting our second speaker, Mr. Arun Kasi. While waiting for him to come in, let me brief you on his biodata. Mr. Arun Kasi is a senior counsel, specializes in civil litigation, arbitration, and international commercial agreements. His major areas of practice include arbitration, shipping, and commercial contracts. He is the president of International Society of Admiralty and Arbitration Lawyers, London. He has advised clients on all aspects of shipping law and in international shipping agreements, and has been writing in law regularly since he graduated at his age of 19 years. He is currently doing a major work to be published in civil procedure. He has authored a book on contract law 21 years ago and has recently authored a book on arbitration. He has served in the Kuala Lumpur Bar Committee as a co-chairperson of Civil Practice Committee. He is currently serving as a member of the committee in Inns of Courts, Malaysia. Without further ado, please welcome Mr. Arun Kasi.
Very great morning. Yang Amat Berhormat Dato' Sri Diraja Haji Adnan bin Haji Yaakob MB Pahang, Professor Dato' Sri Dr. Ashkar Ali, Dean of Kuliah of Laws IAUM, Tun Abdul Hamid Muhammad, former CJ of Malaysia, Yang Arif Dato' Dr. Muhammad Naim Mokhtar, Judge Sharia Court of Appeal, Professor Dr. Nick Ahmad Kamal of Kuliah of Law IAUM, Dr. Azmi Harun, Director of the Sympossium, students, lawyers, distinguished guests, ladies and gentlemen. Okay, I am thankful to ICOL for this opportunity to talk on this subject, which I will in fact say is a novel subject. Okay. The peak of the subject that I'm going to speak on is on the supremacy. That is, which is supreme, Constitution or Parliament? This is a very difficult and controversial subject. Okay. The reason being, Parliament is empowered under the Constitution. If you just look at that, Parliament is empowered under the Constitution, that will say Constitution must be supreme. But the difficulty arises, the empowerment includes the power to amend the constitution itself. So this will say then parliament is supreme. More or less, this could be a chicken and egg story. But we will deal with it now. Okay, and before I venture into the discussion of which must be supreme, I need to say a few words about the unique nature of Malaysian constitution. Our constitution is different from other Commonwealth constitutions or popular Commonwealth constitutions like Indian constitution or the popular unwritten constitution like UK constitution. And that is the reason I said we have some unique features. Okay, let me take through one example why I said this is very unique. Okay, we all commonly know that there are three separate powers. That is the legislature, executive and judiciary. So three powers. This is very true in India. This is very true in UK. But is that so true in Malaysia? This could be something quite new. I would say there are in fact four separate powers in Malaysia. And the fourth power is His Royal Highness Yang di-Pertua Agong. If we look at the constitution closely, His Royal Highness becomes the supreme head. So we have four powers here. Okay, one might instantly think, well, in India also we have the president. And there's a lot of difference between His Royal Highness and the president. In Malaysia, His Royal Highness is the commander of armed forces without any executive shackle. And this doesn't happen in India. President doesn't have such powers. So here the armed forces comes as a separate power under the His Royal Highness. So this we have to admit to be a fourth power. This is what, in fact, in a judgment in Indira Gandhi case at Court of Appeal, Justice Amit Sultan said, he labeled the fourth power as the fourth pillar. I think that was something very new to give it a label as a fourth pillar. And I would feel that was very rightly done so, because in our constitution, unlike the Indian constitution, His Royal Highness has a substantial power, in particular, control of the armed forces. So it would not be so right to think his role is merely ceremonial, like what could be in India. But it is not so here. Okay, having said that, our constitution could be different, or is in fact different, in material aspect from other constitutions, we need to look at the question of what is supreme, or who is supreme, from the very perspective of our own constitution. Okay, so on the question of, we will now go to the question of which power is supreme. Okay, we have cases in Malaysia at both extremes. At the one extreme, we have cases that will uphold parliamentary supremacy. Cases like Lim Kit Siang case and many more. On the other hand, we also have cases that will uphold constitutional supremacy. And we say the most recent case upholding constitutional supremacy was Indira Gandhi's case decided by the federal court. Okay, I said that it upheld the constitutional supremacy because it said that even a constitutional amendment will be checked by the judiciary to see whether it doesn't hamper the basic structure of the Constitution. I mean, what is basic structure, whether right or wrong, we will go into in a while. But before that, the court recognized constitutional supremacy. Okay. The importance of this difference is something very crucial, because if one applies constitutional supremacy to a case, he may get one result. But if he applies to the same case parliamentary supremacy, he may get a result that is right opposite that. If I may again borrow the words of Justice Hamid Sultan in the Indira Gandhi case at Court of Appeal, I would say the difference is not one between apple and orange, but one between marble and pumpkin. Okay, and I will now firstly look at the UK's position before we come to India and Malaysia. In UK, there's no written constitution. And it cannot be doubted that in UK, Parliament is supreme. Okay, then we are talking about parliamentary supremacy or constitutional supremacy. Okay, what does parliamentary supremacy means in the first place? Parliamentary supremacy means that the power of the sovereign rests on the parliament. When we say the power of the sovereign rests with the parliament without restriction, it could in fact go near to dictatorship. If the majority of the parliament want to make law, that will be self-serving them. There is nothing to stop them. The only way that the law can be overturned is by voting out the parliamentarians. Other than that, the law itself cannot be challenged. If in UK, suppose parliamentarians make law that will be self-serving, what will the courts do about it? In fact, they don't have a role to do anything other than serving the law that will be self-serving, because Parliament is supreme. And in a book entitled The Constitution of the UK, the author Peter Leland said this well: it is the Parliament and not the courts which has a final word in determining the law. This is what will happen in a jurisdiction where Parliament is supreme. So there will not be a supreme policing role, a policeman's job that the court has to do in a country where Parliament is supreme. They just have to interpret the law. If suppose in those countries, if parliamentarians abuse their powers, what can the public do? There's no recourse to public other than waiting for the next election to vote out the parliamentarians. In other words, within the law itself, except for the election rights, they don't have other recourse. Okay. In those countries, again we go back, is there a requirement that the legislation must be reasonably made? That is not that it is up to the parliament. They have been already entrusted to do the job. Okay, that is premised on a notion parliament knows best what is good for the people. We have left everything to the parliament. Okay, the scheme has been very workable in countries where the large majority of public are well informed. With a well-informed society, it is hard for any unjust law to be passed arbitrarily, because the society is well-informed, and if a parliament does something, the next moment there is going to be an election and the parliamentarians are going to be voted out. And in those societies, the system is that the role of the judiciary is to be subservient to the legislation. In those countries, again, if you look at the judicial review, the scope of judicial review is quite limited. The courts will hesitate to interfere into policy matters of government. Definitely, they are not going to interfere into legislative matters or legislation. They are not going to review that. An executive decision, they will be willing to review. But coming to policy, they are going to be slow. There is no doubt that an English court cannot strike down a legislation. And that is different from a position in Malaysia. In Malaysia, if a legislation, an act is made which is contrary to the constitution, the act becomes unconstitutional and is liable to be struck down. That is quite clear and that cannot be disputed. It is quite expressly spelled out in Article 75. That is, in the event of inconsistency, constitution shall prevail. That is not the difficult area, but the difficult area is when the constitution is itself amended. That is a difficult area we are going to go into. Okay, and before we go on to the Malaysian position, we need to look at the oath that the English judges take and the oath the English parliamentarian take. Because later we will go into the difference in the oath. Okay, the English judges take an oath as this: I, so and so, do swear by Almighty God that I will well and truly serve our sovereign lady in the office of whichever the office is holding, and I will do right to all manner of people after the laws and usages of this realm without fear or favor, affection or ill will. And English parliamentarians take an oath as this: I, so and so, do swear by Almighty God that I will be faithful and bear true allegiance to Her Majesty, her heirs, successors, according to law. So help me God. Okay. Having looked at the position in UK, where Parliament is supreme undoubtedly, we will now come to the Malaysian position. As I just said, one thing is clear: Parliament cannot make a law that is inconsistent with the Constitution. They cannot pass an act that is inconsistent with the Constitution, Article 75. So what is then the more controversial area is Parliament passing a legislation that will amend the Constitution itself. That is a more controversial area. Okay, before we deal with this controversy, let us take an example of a law that the Parliament could possibly do. I mean, for the purpose of just this analysis, let us just imagine a law that the Parliament may make. Let us say Parliament wants to amend the Constitution by providing that if parliamentarians from a particular state commit an offense under the penal code, then they will be punished to a maximum limit of half the sentence provided in penal code. Let us just assume this for a while. This will be an extreme example of a self-serving legislation. And knowing that they cannot make this into a separate piece of legislation, let us say Parliament has the majority in the Parliament. I mean, the parliamentarians or a particular party has a majority in the Parliament, and they make use of or abuse their majority to amend the Constitution to say this. So when we say amend the Constitution, now they are going to touch on Article 8. Because Article 8 says all are equal before the law. But now we are going to amend the Constitution, say provided that MPs from this state shall only be sentenced maximum to half. Can the Parliament do this? That is the question now we are dealing with. If we barely look at Article 159, yes, they can do it. Because 159 says with a special majority, they can amend the Constitution. And this is where the difficulty comes an Indian judge will come out to say, oh, that affects a basic structure and the parliament cannot do it. As Tun pointed out very well, the difficulty here arises, Article 159 says one thing, that is parliament can amend. But judges have invented what they call the basic structure jurisprudence, which has also been imported into Malaysia. But that you cannot find it within the constitution, or you cannot find where the basis of basic structure comes in the constitution at the face of it. Okay, now we need to look at the oath taken by the executive, the legislature, and the judges in Malaysia. In fact, in Malaysia, no one is exempted from oath. Even His Royal Highness takes an oath. Okay, but anyway, we will deal with the oath taken by legislature, executive, and judiciary. The oaths are found in Schedule 6 of the Constitution. The oath taken by an MP is this: I, so and so, having been elected as a member of the House of Representatives or the Senate, do solemnly swear that I will faithfully discharge my duties as such to the best of my ability, that I will bear true faith and allegiance to Malaysia, and will preserve, protect, and defend its constitution. In fact, we have been often saying the oath is to preserve, protect, and defend constitution. At a very close reading, in fact, the oath comprises 3 distinct parts. But our focus has always been on the third part, that is preserve, protect, and defend constitution. The earlier 2 parts are faithfully discharge my duties of that office. Second part is that he will bear true faith and allegiance to the nation. He cannot go away from these 2 duties. And the third one is to preserve, protect, and defend constitution. Okay. Now, we have already said basic structure. It is hard to support the basis of basic structure. But if you look at the constitutional oath taken by a parliamentarian, he has already taken an oath to preserve, protect, and defend the constitution. Having taken that oath, can he make a law that is inconsistent with the constitution? This is a further question that we need to think of. What, in fact, the Indian judges have not thought of when they say basic structure. They left it quite unfounded, no, that the basis is difficult to understand. But if you look at a constitutional oath that parliamentarian takes, that may support. Then why we say a parliament cannot change the basic structure? Because every parliamentarian has taken an oath to defend the constitution. So when a bill is passed that will hamper the constitution, can this parliamentarian vote for that bill? If he votes for the bill, is he going to be in breach of his oath? He is sitting in parliament having taken the oath. If he does something in breach of the oath, could that not be ultra virus? If we agree it is ultra virus, the next thing is that his vote has to be nullified. If all the votes are nullified, no bill is passed to amend, or no bill is validly passed to amend the constitution. But of course, certain things can be amended that doesn't go inconsistent with the constitution, or what the Indian judges will call what is not falling within the basic structure. That can be amended. But once it falls within the basic structure, that cannot be amended. Probably if you look at the constitutional oath jurisprudence, that approach may be supported. In fact, the constitutional oath jurisprudence is a Malaysian approach, or a very Malaysian approach, that for the first time came out in the judgments of Justice Hamid Sultan. He had written it in numerous judgments And if I recall rightly, the last was Indira Gandhi case, where he had written the jurisprudence of constitutional vote at length. I would add to that by saying, no doubt Article 159 doesn't put any limitation. It doesn't say in 159, but it made, the Constitution on the whole made every parliamentarian bound by the oath. I would say that would be sufficient, in fact, to support the basic structure jurisprudence. Although we don't have to call it basic structure jurisprudence, or the better approach will be to call it constitutional oath jurisprudence. It makes it easier to understand the basis why we are saying so. And I would add on to that by saying constitutional oath is the magic built into the Constitution to protect its basic structure. Perhaps if Indian judges had said this way, that would not have caused this much of controversy or challenge to the basis. Okay, having said a few words about the constitutional oath and the basic structure, I would, in my personal view, I would support the position that Parliament cannot amend the Constitution unconstitutionally or inconsistent with the current Constitution, because, not because I wouldn't call it a basic structure, but because parliamentarians has taken a vote to defend the Constitution. Okay, the oath jurisprudence actually doesn't stop with amendment to Constitution. It has got more to do, because the oath is also taken by executive and judiciary. And if you look at the full oath, it is not merely to preserve, protect and defend the Constitution, but also to discharge the duties of that office and to have a true faith and allegiance to the nation. So any officer who has taken this oath, in my view, cannot act arbitrarily. He has to act in the best interest of the office he is holding. So this oath also goes to arrest arbitrariness, be it in legislative, be it in executive or judiciary. In fact, the oath, if you look at it from this angle, the oath forms a strong basis of judicial review in Malaysia. And the oath gives us a wider judicial review scope than that in UK. Because in UK, they do not have a oath of this strength. Okay, so I would then be for constitutional supremacy is what is in play in Malaysia. Okay, having said this, then why are we having so much of, is there a reason why we are having so much of controversy, and why quite a number of us tend to think it is parliamentary supremacy? Perhaps that could be owing to the fact that we are a Commonwealth country and we had been trained by the British. And so it tells then why we think the British way or the UK constitution way, where parliament is supreme. Probably that could be the cause of this confusion. Okay, having said a few words about judicial review, I would say if anyone in Malaysia acts in breach of the oath, that is acting arbitrarily will be in breach of the oath, he will be acting ultra virus. The moment it is ultra virus, then any decision he makes has to be a nullity. I would say it is not even so much that the court reviews and at the discretion cancels quashes any decision made by the executive or any other body. It is more, the moment they exceed the their powers, that is, they act ultra virus, the decision is a nullity. Okay, and before I complete my short speech, and having touched on judicial review, I cannot stop without quoting His Royal Highness Raja Ashran Shah's time-standing judgment and words in Sri Lanka case, where he said, unfettered discretion is a contradiction in terms. Every legal power must have legal limit. Otherwise, there is only a dictatorship. I would again say this will also be supported within what we could call the constitutional or jurisprudence. You have taken an oath. You cannot exercise your powers in breach of the oath, meaning you cannot, in your office, you cannot act arbitrarily. If you do so, that is ultra virus and a nullity. Okay, well, I wouldn't take more than this with the floor. I'm thankful for the opportunity given to me, and with this, and I'm thankful for the floor for being with me over this speech, and with this, I will close my speech. Thank you.
Thank you, Mr. Arun Kasi, for the most interesting talk. Our third speaker is none other than our own labour law expert, Professor Dr. Nik Ahmad Kamal Nik Mahmud. Before that, a brief introduction on our distinguished speaker. Professor Dr. Nik Ahmad Kamal graduated with LLB from the University of Malaya. He obtained his LLM from University of London, Diploma in Sharia and Law Practice from International Islamic University Malaysia, and PhD from the University of Aberdeen, Scotland. He specializes in labor law and industrial relations law, constitutional and administration law. He was also involved in 2 book projects as a co-author, Administrative Law in Malaysia and Employment Law in Malaysia. He is also the panel auditor for Agensi Kelayakan Malaysia, Malaysian Qualification Agency MQA. He chaired 2 committees under the Ministry of Higher Education to review and amend the Universities and University Colleges Act 1971 and the Private Higher Educational Institutional Act 1996. He was the legal advisor of International Islamic University Malaysia. At the international level, he was the chairman of the Board of Governors, Asian Law Institute, and also was the president of the Asian Society for Labour Law. Without further ado, please welcome Professor Dr. Nik Ahmad Kamal Nik Mahmud.
Thank you, Dr. Shafina. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala Rasulillah wa ala alihi wasahbihi ajma'in. Assalamu alaikum warahmatullahi wabarakatuh. Respected members of the audience and also dignitaries and students, I would like to thank the faculty, the Kuliah, for inviting me to give this view on a very important topic and a difficult topic actually. For me, I've left constitutional law for a long period of time, actually since maybe 10 years ago. But Alhamdulillah, recently I've been asked to teach constitutional law. So all came back, Alhamdulillah. And many of here are my students, I think, both at the undergraduate and postgraduate level. So I'm not repeating the lecture that I've given you actually. I've prepared slides for this one, Alhamdulillah. And there are many slides, but definitely I'm not going to refer to all the slides. Otherwise, it will take more than 1 hour. But after listening to the 2 prominent speakers earlier, the 2 keynote addressees, Yang Ahmad Berhormat, our Menteri Besar, and also the Tun Hamid, I think we are probably receive a different view as to whether the basic structure doctrine is viable or not in the light of our constitutions. But because I already prepared the slides, might as well look at some of the views on this issue. Okay, can we see first? The first slide is on the judicial oath, as per the Constitution, in the schedule of the Constitution. You can see that the emphasis, which I've already emphasized in red there, that the judges will preserve, protect, and defend the constitutions. As Mr. Arun has already mentioned the oath earlier. In fact, he went further to mention also the oath of members of parliament. But I will confine to just the judiciary for my speech today. Next, please. Now, when we talk about rule of law, I mean, Ahmad Berhormat, Datuk Seri Adnan mentioned about Daisy is pronounced as Daichi or Daisy. But I think most of us pronounce Daisy, right? For those who are the constitutional law students in the first semester, I mean, at least in this university, they will be studying about the rule of law. And they will have to know Daisy by heart. Right? So what Daisy said, there are three important principles which Daisy said. That is, whenever we have law, then only the law can actually punish a person. Meaning to say that no man is punishable except for a distinct breach of the law. Secondly, that we have equality principles. And thirdly, of course, the courts play an important role in upholding the rule of law. Now, these three important principles that Daisy have laid down in his book when he was studying the English law, the English constitutional law at the time, had not taken into account many issues, in fact, many practices. Now, he was frowned off the practice of the French, the droit administratif, if you still remember your constitutional law. Okay, can we go to the next slide, please? Now, these are the critics of Daisy. Now, many have written, even at the time when Daisy was publishing his book. Now, many had written to criticize Daisy's principle. I've got some of these views about Daisy's principle of rule of law. For example, Sir Ivor Jennings, of course, another well-known, constitutional law commentators. He said that the principal rule of law of Daisy has not taken into account that there are many discretionary powers that given to the executive, especially. That's number one. And there's also Friedman who wrote recently that the notion of government is that there is no equality between the government and the citizen. Listen up. Because the government is to govern the citizen, then how can there be equality? And there are also many other critics. If you go through the critics of Daisy, there's so many of them, right? But yet, can we go to the next slide, please? But yet, we, in any states with constitution, whether written or unwritten, there are only 3 countries in this world have unwritten constitution, right? I always ask this to my students. Besides UK, what are the countries? What are the countries? New Zealand and Israel, right? So, yet, rule of law is important. But rule of law has to be adapted to modern circumstances. So that's what happened to Lord Bingham, former Lord Justice of the UK courts. Now, he came out with very interesting sub-rules of law. Okay, there are 8 of them. So if I can go very quickly. Number 1, that law should not be so vague. Secondly, legal rights and liabilities must ordinarily be resolved by the application of law and not by the exercise of discretion. Okay, so he emphasized of legal rights and liabilities. He does not reject discretion, but when it comes to legal rights and liabilities, it has to be decided by law, but not by discretion. Thirdly, he mentioned about equality is good, but yet we should also allow rational classification or differentiations of treatment. And of course, number 4, he said about fundamental liberties and protection of human rights. And number 5, number 6, and so on. Okay? So this restatement or reconstruction of rule of law is important. And in 2009, the International Bar Association had come up with their own sub-rules of the rule of law, okay, which emphasize on, for example, can we go to the next slide? Yeah, this one, right? The existence of an independent judiciary, the impartial judiciary, the presumption of innocence in case of criminal accusation, the prerequisite of fair and public trials, the observance of a rational and disproportionate approach to punishment, the existence of strong and independent legal profession. Next. Okay. The strict protection of professional secrecy, the maintenance of equality or fall before the law, the absence of arbitrary arrest and secret trial, the absence of indefinite detention without trial, the exclusion of cruel and degrading treatment of punishment, the absence of intimidation, the conduct of governance in society, and so on and so forth. 12 altogether. So, well, with this restatement and reconstruction of rule of law, we are, I believe, in the same state of affair, in the safe state of affair. So we are in the right direction, and in the reflections of the rule of law principle in our constitution, next please, we have the principles of supremacy of law as per the constitution. Which says that punishment that can be imposed must be based on the law that exists. We have the principle of supremacy of the Constitution in Clause 1 of Article 4. We have Article 7 that prohibit retrospective criminal law and repeated trials. Next, please. The second principle of the rule of law by Dicey, we have Article 8, of course, with some exceptions, many exceptions, in fact. Okay, and the third principle of rule of law, we can see that Article 4, the supremacy clause, we have Article 4, Clause 3 and 4 that gives the courts the power to review law made by Parliament and made by state legislature. We have the powers of the court as per Article 121, right? Despite it being taken away, the judicial power in Article 121, but the recent case of Indira Gandhi, the court re-emphasized the importance of judicial power despite the provision of judicial power has been taken away by the amendment to Article 121. And of course, Article 128, which gave the federal court the power to declare law to be unconstitutional, law made by Parliament or law made by the state legislature. Right, so that is rule of law, because my topic covers two aspects, that is the judiciary with the rule of law and the judiciary with the supremacy of the Constitution. Next is the constitutional supremacy. As we have seen in Loy Kwi Chun, the emphasis of constitutional supremacy is basically three. Number one, that the fundamental rights which the state cannot encroach, where it is not allowed to encroach. That's number one. Number two, the distribution of powers between the states and the federation, or the federal principle that we have maintained so far. And secondly, the disseparation of power between the executive, the legislature, and the judiciary. Thus, so in order for the supremacy principle to be upheld, right, Raja Azlan Shah, who was one of the judges in Loy Kwi Chun, has said that, however, the statement that in Article 4, Clause 1 is somehow or other redundant. On the ground that, how can a law that says is supreme, say it in itself, right? So that is what he said. But anyway, Raja Azlan Shah in Loy Kwi Chun has insisted that when there is amendment to the Constitution, it is valid as long as Article 159 and Article 161 are followed. I think Muhammad Datuk Sri has mentioned this earlier, and also Tun Hamid just now. And the court has power to invalidate any law that is passed which is unconstitutional, and also law passed after Merdeka Day which is against the Constitution shall be void. So in that respect, the word law refers to law made by Parliament, okay, but does not include constitutional amendment law. That was what Loy Kwi Chun was insisting on, okay. And of course, the other one, which is still very controversial today, is the presumption of validity. That law made by Parliament is valid unless proven invalid in the court of law. Right? Of course, I will not go into that issue because it's not the scope of this paper. So then we have this doctrine of basic structure, which I will not repeat what have been said earlier by two our prominent speakers, right? But basically, Loy Kui Chun decision was frowned about insisting of the existence of such doctrine on the ground that otherwise then the court would usurp into the powers of Parliament. The court is not given the mandate to make law. So the court should not be making law when Parliament is the exclusive authority to make law. That is the basis of the rejection of the doctrine of basic structure in Loy Kui Chun. But of course, earlier, there was already an arbiter, okay, mentioned in the case of Government of State of Kelantan and the Government of the Federation of Malaya and Tunku Abdul Rahman, where Thomson CJ said that unless the change made by Parliament in the Constitution is so fundamentally revolutionary as to acquire fulfillment of a condition which the Constitution itself does not prescribe. So some seed was already sown on the basic structure doctrine in earlier, but of course rejected, clearly rejected in Loy Kui Chun. And of course later on, next please, Pang Chin Hock also rejected this doctrine when Sufyan LP was saying that we cannot follow the Indian Supreme Court because the basis of the Supreme Court of India judgment was based on their constitution, which was drafted by their Constituent Assembly, and that the Indian Constitution has a preamble and a directive principle that they can rely upon, that we do not have. The Constitution of Malaysia does not have a preamble, and we do not have a statement of principle. So in that respect, we cannot rely on the Supreme Court in India on this issue of basic structure doctrine. Right. Can we go to the next slide, please? Another one? Yes. So the departure had started, of course, as mentioned earlier, in Semenyih Jaya Senayan Berhad, and later on, cases of Siva Rasa. Okay, next slide, please. And most recently, 2018, reported in January. Next, please. Yes, this one, Indira Gandhi. Right? On the basis that the fundamental underlying principles and the role of the judiciary form the part of the basic structure of the Constitution, being something fundamental and essential to the political system. Now, of course, many has been said, and I would not go into repeat those. And what can we conclude? Next slide, please, on this issue of basic structure. At least there are two principles of structure that have been identified in Semenyih Jaya case. First, the doctrine of separation of power, and secondly, the independence of the judiciary. And of course, in Siva Rasa, the fundamental rights provision in Part 2 of the Federal Constitutions, and in Indira Gandhi, the issue of judicial power and the power of judicial review. So, what next? What else? Of course, when we look at the Supreme Court decision of India, it mentioned about the basic structure to be decided based on case-to-case basis. So we have 3 cases, and they have laid down at least 3 basic structure. What else, like what I was saying? So this would definitely left to the courts to decide, right? So if, of course, the courts later on would continue to accept the principles of basic structure as per decided by the 3 cases of the Federal Court. But of course, what we have heard this morning was an argument to the contrary. So as law students, I believe that you would be allowed to evaluate both views and then decide. Decide not based on emotion, rather to decide based on the total constructions of the constitutions. Okay, now on the doctrine of supremacy of the Constitution, can we go to next? Yes. I've referred to Andrew Harding. Now, Andrew Harding has written a lot about Malaysian Constitution. One of these important books that has been published in 2006, which I referred to. Harding was referring to this issue of people making comparison about constitutional supremacy and parliamentary supremacy, which he said that one cannot confuse. Even the student of constitutional law sometimes confused the difference between constitutional supremacy and parliamentary supremacy. But leaving that aside, Harding was saying that there are factors actually can affect constitutional supremacy. Now, he mentioned at least 5 factors. That is basically, he was referring to whether the party in power has a 2/3 majority or not in parliament. Okay, if the parties in power have a 2/3 majority in parliament, like what Datuk Seri had mentioned this morning, that the ability to amend the constitution would be much easier compared to a party that does not have a 2/3 majority. That's number one. Number two, 2012 saw the repeal of many emergency laws. I think this is very significant. The idea of transformation by the Yang Amat Berhormat Perdana Menteri had shown an important aspects of recognition of rights. Okay, the repeal of ISA after that. Okay, the repeal after that also of Section 27 of the Police Act and the promulgation of the PPAA, Peaceful Assembly Acts 2012. And of course, we have seen also many other changes that made that would show an important improvement to fundamental liberties and the upholding of the fundamental rights under the Constitution. Now, the third point is that whenever a constitution is amended, I think Arun has mentioned earlier that the feeling is that when you amend the constitution, it's not just amending an ordinary law. Amending the constitution is actually amending important principles of the constitution, such as fundamental rights, states' rights, rule of law, separation of powers, and also it is not just from the point of view of politics. It has constitutional value in those amendments, right? So I think Arun correctly mentioned about the need for parliamentarians to understand that whenever they are agreeing to the amending of the constitution, they would be actually going to give effects to the total structure of the constitutions. Okay, that's number 3. Number 4, whenever the principle of constitutional supremacy is upheld, then members of parliament should be aware that whenever the law is unconstitutional, then it would not see the light of the day. Even if it sees the light of the day, it will be next to be declared unconstitutional by the court. Okay? Now, of course, Harding also mentioned about legal supremacy or sovereignty must not be confused with political supremacy or sovereignty. Okay? So even if a political party has a 2/3 majority in parliament, they would not be the supreme authority because still the constitution is supreme. Okay, now on the issue of, can we go to the next slide, please? The issue of the courts, the constitutional supremacy and the rule of law. I would like to refer to Shad Salim Faruqi's statement on this. And of course, we know that Shad had been writing a lot on about the Constitution, the rule of law, the supremacy of the Constitution, separation of powers, fundamental rights in his weekly column in the Star. And I've referred to one of those writings. he was, in fact, emphasizing that the need to have the principle of constitutionalism imbued to every citizen of the country. But of course, he accepted the fact that constitutionalism takes years or decades to develop root. So it's not easy to have that realization, the importance of constitutionalism or limited government. So Shad has made it very clear that we live in a country which is built around the rule of law, the separation of power, the supremacy of the constitution, and the independence of judiciary. And this has been intact, alhamdulillah. But of course there are, there are loopholes here and there, but alhamdulillah, I think more than 60 years of independence, I think we are able to live within that framework peacefully. Now, he mentioned about the provision of fundamental liberties that has been preserved, has been protected by the courts and also by the government to the extent of what is allowed in the provision of fundamental liberties. Of course, fundamental liberties that we have in Part 2 of the Constitution is not absolute because they are already conditions, they are exceptions, which I think the law has been in line with that. And he mentioned about the army and the police are not on their own, they are under civilian control. I think this is significant. Now, he mentioned about changes made since 2012, the repeal of emergency law, the repeal of the Internal Security Act 1960, the repeal of Section 27, the amendment to the Printing Presses Publication Act, and many more, right? And of course, the establishment of Suruhanjaya Hak Asasi Malaysia, Suhakam, which I think is also very significant for Malaysia. Now, I also have a liberty to refer to other writers, and a well-known former Lord Justice, Michael Kirby, who came to Malaysia many times and gave speeches. Can we go to the next one? Yeah, this one. Now, he was referring to the rule of law in his speech, one of the speeches in 2000, I think 2002 or 2003. Now, he made this statement about the rule of law where adherence to the rule of law alone is not enough. Because rule of law must comply with substantive human rights values. That's number one. Number two, rule of law should honor and promote individual freedom. I think this is something that goes beyond what the rule of law has. Okay, next please. Now he went on to say that whenever this question being raised about whether the court should be active or judicial activism, I think Datuk Seri had mentioned about judicial activism this morning, and he warned this, that the courts can be accused of being the tool of the government if they just read the law as it is. That was his warning. But then he also raised another warning to it, that then should the court interpret the law creatively, that is to promote judicial activism or not, right? So should the court use literal interpretation or use other form of interpretation that expand the meaning of the words in the law, right? So we have seen this in this country. We have seen judicial activism as per the doctrine of basic structure just now. We have seen judicial activism elsewhere in other issues that has been raised in the courts. Next, please. Next, please. Now, but then, of course, there are cases that, or there are issues of fundamental rights which I think require some judicial activism. Now, I was referring to Ong Ah Chuan, okay, the Singapore Supreme Court decisions on the meaning of law, because law is literally means law made by Parliament, but the law interpreted by Article 160 does not mention those extrinsic values or extrinsic elements of, say, natural justice, principle of morality, and so on and so forth. But Ong Chuan said in the decision reported in 1981 that part of the system or part of the history of common law has accepted that law should incorporate the principle of natural justice. What is natural justice? Right to be heard and rules against bias. And of course, not just that, the principle of fairness, which I think has been insisted by the court in Ong Chuan. But in Malaysia, in Cik Ani bin Cik Itam case, even though the court agree that this should be the case, that law should be interpreted incorporating the principle of natural justice, morality, fairness, but then the court was saying that, well, the law that was in question, FIPA, the Firearms Increased Penalty Act, which imposed mandatory life sentence, was not arbitrary, fanciful, or oppressive. So in other words, the court is willing to go beyond the words of the law, provided that it is suitable to do so. Right? Now, next, please. But in Beatriz Fernandez interpreting Article 8, everyone knows about what happened to Beatriz Fernandez, right? Because she was said to be discriminated as a member of the Malaysian airline system simply because she was pregnant and therefore she had to resign. But that requirement of resignation was already incorporated in the collective agreement agreed upon between the union that she belonged to and also the employer. So when it was raised that this is discriminatory as contrary to Article 8, the court said, no, it is not. Why? Because Article 8 does not mention about private agreements. Because Article 8 mentions about law and executive decision made that is discriminatory. But if it is a private agreement, like collective agreement, then it would not be discriminatory. So again, of course, there's a lot of criticism about the judgment. Then again, how one would argue that the court was not unreasonable in the interpretation of Clause 8? Because it's already stated clearly in Clause 8, isn't it? But then again, why can't the court also incorporate the principle of fairness and this issue of interpretation of equality principles? So what I want to stress here is that it is not right to say that the court is always literalist in its approach, because there are cases that where the court used the principle of natural justice, and in some cases as well, the court tend to be literalist in its approach. Okay. Now, I still have 5 minutes. Let me just go through because there are other. We should allow more questions. Okay, let me just go through. Can we just go to other slides, please? Can we go further down? Okay. Okay. Problem. Can we go back a bit? Go back. Problem with rule of law. I think when we have rule of law, there are problems of applications. I mean, the court is aware of this, but sometimes the court's hand is tied. Okay, so it has to be left to the legislature to then look into law that may be restrictive, maybe against the fundamental of against the rules, the human rights, or it may be contrary to the principle of fairness and principle of natural justice. So there's a need to see that justice to be done, of course, and when it comes to law, the application of the law should be fair. Secondly, whenever we have strict observance of the law, then sometimes it will not guarantee just and fair society, because law is not just one instrument. There are many others. The economics, the economy, the social issues, all these should come about as well as to help to ensure fairness. There are wide discretionary powers that we have given the executive under the law. I think this should need to be looked into. We have the need to consider laws from the point of view of internal security and defense. Of course, SOSMA, POTA,
POCA, these are new laws, right? That take over the so-called strict rules in ISA, but yet it is justified because of the need of security and defense. Next, please. Public policy and public goals are there necessary to ensure the achievement of fairness, equality, that the below 40s are supported in many aspects. So there's a need to look into this. Right? Then, of course, we also have vast power of the government. Next, please. Immunity and privileges are given to certain sectors of the society. It is necessary, but then again, it may be contrary to the principle of rule of law. Next, please. The infringement of natural justice principle, which I think can be improved further. There are good decisions of Hong Kong equipment, of course, from the point of view of rights. I think reasoned decisions is good for us to have whenever a government is making decisions against us and affects our life. But then again, sometimes that decision or the reason of the decision need not be given in certain cases. I think it is rightly decided by Suguma Balakrishnan by the federal court that it's not in all cases that the executive should give reason for their decisions. All right, so next please. And there are practical impediments to the supremacy of the law, the rule of the law as well, because there are many things that is still not fair. I think access to justice is still a problem for us because legal aid is still very weak in Malaysia, unlike many other countries. Now, we are only representing the people, those who are charged in criminal when it comes to mitigation, but not from the beginning. Of course, there are situations where the legal aid department would allow some assistance, but then some of these legal assistants, they are young and new, they do not have the experience yet, so yet they have to defend a person who has been charged in very serious cases. Now, let me just go to the conclusions. Can we go to the conclusions? I just want to share with you, this is from Michael Kirby's paper. Now, he was referring to Ronald Dworkin books, okay? When Ronald Dworkin was writing a book on justice in Europe, he said, when there was this anecdotal situation where U.S. Supreme Court Justice Oliver Wendell Holmes, who on his way to the court was greeted by another lawyer who said, "Do justice, justice." Justice Holmes replied, "I am not here to do justice, but to decide cases according to the rules." So that perhaps reflects the whole issue that we have today. Okay, that reflects the whole issue of the dilemma, if I would say the word dilemma, among the judges, that whether they interpret the law as it is, literally, or they should incorporate the principle of natural justice, fairness, and morality into the law, where the law is silent about this. Thank you very much. Billahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Prof. Dr. Nik Ahmad Kamal, for the very resourceful talk. Distinguished guests, ladies and gentlemen, the next agenda is the question and answer session. And for that, I would like to invite all distinguished speakers on stage. We also have our own constitutional law expert, Associate Professor Dr. Khairil Azmi Datuk Mukhtar from Ahmad Ibrahim Kuliah of Laws, who will be the moderator for this question and answer session. Without further ado, I hand over this session to Dr. Khairil Azmi.
So first, please open the floor for questions.
Assalamualaikum warahmatullahi wabarakatuh. Aliza, lecturer from ICO. Usually when it's an internal event, I don't like to ask questions because we can discuss internally. But I'm very interested in this topic because actually for my entrance essay for my master's in Oxford, I wrote about basic structure doctrine. And at that point of time, I was very much in support of basic structure doctrine. And after hearing the two keynote address, I'm starting to reconsider my view. However, I still feel that there is a need. Now, let's call a spade a spade. The reality is the climate today is that there's a strong feeling of mistrust on the part of the government, because like Prof. Nick said, when we talk about rule of law, this cannot be divested from human rights. But there has been a lot of laws passed that is seen to be against fundamental liberty, which is felt by the people, aimed at suppressing dissent, such as Akta Sakit Hati, the Multimedia Communication and Commission Act, the Peaceful Assembly Act, and now the Fake News Bill. So the people feel that now we are looking at the judiciary, right? So policing role of judiciary to ensure this check and balance. I think this is the reason why majority, if we read, is in favor of basic structure doctrine, because we feel that this is a way for the judiciary to exercise its function, right, as check and balance tool on the part of the legislature. Because of this feeling of mistrust, whether it is justified or not is a separate debate, but there is that feeling. The thing is, we cannot put aside the fact that the judiciary can make law. Yes, legislation make law, but in our common law system, the function of the judiciary is not just to interpret the law, whether literally or with judicial activism, but they can also make law because of the common law system, right? Okay, now the only reservation that I have with the basic structure doctrine is the fact that it is not certain. When it is said that judges can determine this on a case-by-case basis, to me that is the real problem with the doctrine, because different judges will have different interpretation and judges change. Federal court judges, they are not fixed. We have future judges coming in. So is there a way, I'm asking our constitutional law experts here, is there a way where this basic structure doctrine can be accepted and in place in Malaysia, but is there a way to limit it in a way so as not to be too open-ended? That's my question. Thank you.
Thank you very much, Madam Siti Aliza. I think that question is addressed to all panelists, or any. Perhaps we can address this question one by one. So, we like. Okay, I would like to invite Dato' Sri Raja.
Now, basically, our government of the day is already too old. We have been around for so long. And as you know, when you have been around for so long, then boredom and whatever will set in. That goes, or that applies to almost every aspect of our life, not only to the government. And number two, I'm again perplexed by the fact that people are talking about fundamental liberties, freedom, you know. Now, we must remember, all these things are not absolute, you know. Do you want to have a situation where a convicted burglar, a convicted thief, is to be set free just because his children have nobody to look after them? I don't think it's proper. If you are an offender and then you're convicted, off to jail you go. Now, as for the wife or for the children who looks after them, that's immaterial. That's why you shouldn't commit the offense. Otherwise, your wife and your children will be in trouble. Now, from the way things are going by, brothers, members of the panel, looks like people want democratic, very democratic government, open, transparent, and then freedom of speech, all the fundamental liberties. But we must remember, we live in society. Everything is not absolute. We have freedom of speech, we have Sedition Act. You see? Now, you can go anywhere, you can do your chores, but if you commit offenses, then there's a penal code. Now, back to the basic structure principle. first and foremost, there is no such thing in our federal constitution. Okay, we take a scenario where, okay, the parliament is so oppressive, the government is so autocratic, all right? Oppress the people. Okay, now we look upon the judges to be the check and balance. Now I tell you, power tends to corrupt. Absolute power corrupts absolute. You must remember that. Now, when the judges are given such a wide power, almost absolute, I am telling you, they'll be worse in Parliament. At least Parliament consists of so many members, you know. Judges, we haven't heard a case where the federal court sit on a panel of more than 5. More than 5, no, 5. But Indian cases, the case of Ananda, 13. But the decision was very slim majority, 7-6. Now, in Malaysia, we have never heard a panel of more than 5. And you are giving the power, sole power, to decide whether the government is democratic or not, or whether the laws are harsh or not, just on these 5 people. Now, what if they act arbitrarily, act dictatorially? Thank you. I tell you, sometimes it's better for you not to complete the answer. Keep it hanging. Yeah, let them think.
Okay, the question from the floor, from the lecturer, I think raise some issues of like mistrust in the executive or it could mean the parliament. So when that happens, where is the check and balance? So the lecturer supported that we need a basic structure so that there will be a check and balance. But the concern was what would be the parameters of the basic structure. Okay, firstly, I will deal with the question of mistrust. This is actually a cultural matter, or that could differ society to society. Perhaps a speaker from UK may not say that. In fact, they have left everything to the parliament, and it is, without any doubt, parliamentary supremacy. That, I think, should be because of the culture there. They don't have a mistrust, or they wouldn't say or talk of mistrust. But here, in our climate, we have that worry or that fear. So we need something more than that. I think that justifies why our constitution is different from UK. Because we were colonies of UK, they have an unwritten constitution for themselves. But they promoted a written constitution for us. I think we need to think why it should be so. Because they had the trust in their system so much that they did not feel they needed a written constitution. In fact, until today, they don't have. They're so comfortable with an unwritten constitution and wide powers given to the parliament. But here the lecturer's concern was that we cannot afford to give that. So this is actually a difference in the culture. So given the difference, then it requires that we need then to have a strong check and balance. Okay, then the question comes, if we have a strong check and balance, should we have then parameters to how far the basic structure can go? Whenever we leave it to the judiciary on these kind of matters, or even judicial review, we will see always there's a lot of discretion left to the judiciary. Once we start putting fetters and limitations, maybe the judiciary cannot really do what they have to do to protect the basic structure. So in my view, it may not be a good idea or it may not be possible to put fetters to the jurisdiction. Then the question arises, as Dr. Sri rightly pointed out, Parliament, we have so many parliamentarians there, more than 200. But in judiciary, we have only maximum 5. So is it right to leave so much of discretion just with the 5 persons? Possibly I would think of this answer. I really have to disagree with Dato' Sri. Not disagree, or differ from Dato' Sri. In the court or judiciary is where we have natural justice. That is, parties are heard and then only a decision is made. This is maybe we don't have what we don't have in the parliament. We don't have a right of, or the ordinary public don't have a right of representation other than through the MPs. They don't have a right of representation in the parliament. And to what I know, there is no requirement that the parliament has to consider all the argument before making a decision on what it should do, unlike a judiciary. So with all this, I think ultimately the power need to be left with someone. And in any event, the power need to be left with someone. UK has left it to the parliament. And the judge's role is very limited. They can only interpret the law. Here, I a little earlier advocated constitutional supremacy. If that is so, the supreme policing authority or the supreme policeman can only be the judiciary. And touching on the constitutional amendment, I think I would just add on one word. As Prof. Nick said, the constitutional amendment, we need to be extra cautious because we can see that as cutting on the branch, sitting on the branch and cutting the tree. So an extra caution need to be taken when we are touching on constitutional amendment. That is what India has achieved by what they call basic structure, and that is what I had earlier advocated, constitutional or jurisprudence to protect the basic structure rather than saying it is a basic structure. Okay. Yeah. So this I will leave it to the next week.
My take on that, Liza's question is very, very important questions. First and foremost, the first judgment on the issue of basic structure was, some argued, was arbiter. It was not a ratio of the case. But then the reinforcement in other cases after that made it a ratio. So Indira Gandhi has sealed this issue about basic structure. Of course, judicial activism is actually sometimes important to ensure check and balance between the three organs of the government. But then again, overdoing it would not be good. I think Tone has already made it very clear on this point. But then again, I think the realization of members of parliament about making amendments to the constitution that touches on basic principles of the constitution, which is very important, because if they understand the value, the spirit of the Constitution 1957, understanding the history of the draft of the Constitution and the framers of the Constitution, I believe that issue of basic structure would not fall on the court. It will be on the parliamentarians. Of course, the irony of the basic structure doctrine was that it happened when BN was no longer had that two-third majority. Right? That was the irony. But if it happened earlier when BN was with two-third majority, perhaps one could understand. Right? But then again, judges made law. If this so often, I believe that would not be good for the country, even though it is part and parcel of the common law principle. But then again, we have a written constitution. We have Section 3 and Section 5, which says that if we have the law, then we don't have to follow the common law. Is it not? So in that respect, I believe we have already established our own common law. So that perhaps should be the guides for the future. Thank you.
Thank you, Professor Nick Kamal. Now let us move on to the next question.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Zaidul Rijal Abu Bakar from Persatuan Peguam-Peguam Muslim Malaysia. I have two questions. The first question, before I ask my question, I would like to correct Datuk Sri a bit. The quorum for the federal court did exceed five panel in few cases. Recently, yeah.
I'm sorry. I just mentioned just now, normally they sit on 5. Seldom 7 or 11 or 13 like India.
Yeah.
Can you please list me the cases where or when the federal court sit on a panel of more than 5?
In recent case of bin Abdullah, I appeared before the panel, and there were 7 panel of judges, but it would not equal to 222. Yeah.
Only one.
A few cases, I think. 2 or 3 cases. The challenge to the extension of Chief Justice and the President of the Court of Appeal, more than 5 or so. It has been heard. No decision has been given yet. Okay.
That is an exception rather than no.
Yeah, I would agree. Yeah. Okay. My first question is that whether the judgment in the case of M. Indira Gandhi, whether it is a ratio decidendi or a mere obiter. If we look at the question posted to the federal court, the 3 questions posted to the federal court, nothing to do with the basic structure. There's nothing to do with Article 1211A, but the judgment of Tan Sri Zainon falls short of saying that Article 1211A itself is unconstitutional. And we know from few cases like the Kalimah Allah case, the judgment, the Juzaili, the transgender case, where the federal court decided that, and it is a tried law already, if you want to challenge on the constitutionality of a piece of legislation, you cannot go through judicial review. You have to go through Article 4 of the Federal Constitution. But M. Indira Gandhi, the case based on judicial review. But this has been totally ignored by the federal court in their decision. So whether it is a judicial review, it is a ratio decidendi, or it is a mere obiter. And my second question is directed to Mr. Arun. If I remember correctly what you have said, if I understand correctly what you have said, you did say that you disagree with the term of basic structure to be imported in Malaysia. But you said that it can be done based on the oath of the parliamentarian, right? That's all right. Okay, I've read the oath of the parliamentarian. I quoted in the Malay version because our MPs take oath in Malay. Saya setelah dipilih atau dilantik sebagai seorang ahli Dewan Rakyat dengan sesungguhnya bersumpah bahawa saya akan dengan jujur menunaikan kewajipan-kewajipan saya sebagai yang demikian dengan segala upaya saya, that's one. Bahawa saya akan menumpahkan taat setia yang sebenar kepada Malaysia, number 2. Number 3, dan akan memelihara, melindungi dan mempertahankan perlembagaannya. From this oath, I don't see anything that bar the parliamentarian from amending the constitution. Because you did say on the first limb of the oath, but the first limb of the oath said that saya akan dengan jujur menunaikan kewajipan-kewajipan saya sebagai yang demikian dengan segala upaya saya. Kalau dia dengan jujur vote for amendment of a constitution and it is within his power, then there's nothing wrong to me. Can you enlighten me further on that? Thank you very much.
Thank you for the very interesting question. There is not a doubt that the parliamentarian has taken a vote in the third aspect to preserve, protect and defend the constitution. But if I understand rightly, the question was having taken the oath, he can still amend the constitution, provided that is in the honest discharge of his duties, which is also part of the oath that he has to faithfully discharge his duties of the office. Okay, when we say basic structure, in fact, we are talking about the basic protection given by the articles, such as equality, right to property, no one's property will be taken away without compensation, those type of things, which are basic matters. Okay, when basic matter is amended, or that kind of basic right is amended, as I gave the example where Parliament makes a law to say MPs will only be half punished under the penal code. In the first place, it cannot be a faithful discharge of the duty because that is a self-serving legislation. So I would say that if we are touching on the basic structure, if someone is touching on the basic structure, in the first place, the biggest question that arises is whether the parliamentarian is acting in faithful discharge of his duties. But if we leave that aside, okay, let us say he is faithfully discharging the duty, the second question arises whether he can change the basic structure because he has already taken an oath to protect, preserve and defend the constitution. This is highly arguable. I could say that having taken the oath to preserve the constitution, he cannot knock down the basic structure of the constitution. But one could equally argue, because he's still faithfully discharging the duty, so that should not be caught under his third part of, or third aspect of the oath. So I think this is a very arguable thing. There's no this or that answer to it, and people are bound to have difference in opinion. Okay, okay, I think the Indira Gandhi case, the federal court went into basic structure jurisprudence on whether 121, 1A, some sort of touch on whether the amendment was constitutional. But I think it was a judicial review application, and even without that, there could be many other grounds where they could have come to the same decision. In fact, I have written an article on Indira Gandhi decision that is available, and it was published in London by Commonwealth Lawyers Association. I suppose it should be available on their website. I dealt with those things, and in fact, of course, the federal court could have reached the same conclusion without having to resort to basic structure. But I would feel that federal court took an opportunity to deal with basic structure in that case. It could be obiter or it could be ratio. I think that is highly arguable. Yeah. In fact, in my own article, I said that would not be necessary. So that could say, no, it could be obiter also. But whichever it is, I think whether it's obiter or ratio, I would stand by that the basic structure could be important in the form of constitutional oath jurisprudence.
Thank you, Mr. Arun. So that is why lawyers have subjective questions. You don't answer A and B, it can be either A, B, or in between. Like Dr. Sri. Okay, the time is already up. We have reached 12:30, and I think before, I would like to thank.
I'm just trying to say to brothers and sisters, you remember, all right? Remember one thing, the world is changing. You are experiencing changing times. So everything needs changes, including constitution. I tell you, the one thing that cannot be amended at all, Quran, that's all.
Thank you, Dr. Sri Raja. So that's, I think, basically concludes our discussion. But I think taking into account the idea of judicial activism, I would like to also take into consideration moderated activism. So whereby I'm going to go beyond the duty that I have. We are talking about the doctrine of basic structure. At the same time, we have to understand that we are a democracy. In a democracy, We elect our representative who shall make the law. And what is the law? That is decided by the people's representative. And when we give power to the parliament to make laws, as well as to change the constitution, it is basically the people who speaks. So having this in mind, some people are quite skeptic or have rather cautious about judicial activism. Judicial activism is good, but what is not good is judicial hyperactivism, where judges go beyond what they are entrusted to do. And doctrine of basic structure only exists in India. It only exists in India. It does not exist in other countries. So whether Malaysia would like to follow this doctrine created by Indian Supreme Court or not, it is up for the Malaysian. Okay? At the same time, no other countries have or apply such doctrine. So if Malaysia would like to be like India, then of course, I think maybe that's what we should think. But all other countries have constitutions and their parliament can change their constitution. As including America, and of course, UK has parliamentary supremacy. As well as, and I think I would like to conclude as what Dato' Sri has mentioned, the constitution is not a religious scripture revealed by God. It is man-made law. If it is man-made law, then men have to adopt to changes and circumstances. By that, I end our discussion, and thank you very much. Assalamualaikum.
Thank you, Dr. Khairul Azmin, for moderating the question and answer session and end the symposium today with the closing remarks and general comments. Distinguished guests, ladies and gentlemen, I now have the pleasure to call upon Honorable Professor Dato' Sri Dr. Asghar Ali, Dean of Ahmad Ibrahim Kuliah of Law, to present a token of appreciation to Yang Amat Berhormat Dato' Sri Diraja Pahang Menteri Besar. Honorable Professor Dato' Sri Dr. Asghar will now present some tokens of appreciation to our distinguished speaker. I invite Mr. Arun Kasi to receive a token. I also would like to invite Professor Dr. Nik Ahmad Kamal, Nik Mahmud, to receive a token of appreciation. Many thanks to all our distinguished speakers, and thank you, Honorable Dato' Sri, for presenting the token of appreciation. Ladies and gentlemen, to commemorate this event, may I request Yang Amat Berhormat Dato' Sri Menteri Besar, Honorable Dato' Sri, and our distinguished speakers to please remain on stage for a quick photo session.